All right, let's get right into it. Today, we're cracking open the playbook for something every lawyer and even client needs to understand: how to appeal a decision from the regional trial court. We're going to break down Rule 41, not like a textbook, but like a real step-by-step guide you can actually use. So picture this. You're in court, the judge makes the ruling, and it's not what you wanted to hear. That sinking feeling hits, and the first question that pops into your head is, okay, what now? Is this it? That's exactly the moment we're talking about today, and we're here to give you the answers.
So here's our game plan. First, we're going to figure out the most basic rule. Can you even appeal in the first place? Then we'll cover the things you absolutely can't appeal, the no-go zones. After that, we'll map out your strategic options, talk about the two things you can't mess up, time and money, get the paperwork right, and finally, see how the case gets handed off to the next court.
Okay, first things first. This is the absolute bedrock of the whole process. Before you even think about filing an appeal, you gotta be sure that the decision you got from the court is actually, appealable. Not everything is. Think of it like a boxing match. You can't appeal a single punch in round 3. You have to wait until the final bell rings and the referee raises a hand. That's a final judgment. It means the trial court is done. It's heard everything, made its decision on the main fight, and all that's left is to carry out the verdict. That's when you can take it upstairs. And this is the key distinction you have to get. A final order, that's the end of the game. It's appealable. But an interlocutory order, that's just a ruling on a side issue while the main case is still going on. It's like a ref's call in the middle of a play. You can't stop the game to appeal that call. You have to wait until it's all over. Otherwise, cases would take forever. Okay, so we know we can only appeal final orders. But it gets even more specific. The rules actually give us a list of things that are completely off limits for a standard appeal. Knowing this no-go zone is crucial, because trying to appeal one of these is a mistake you just can't afford to make. And luckily, there's a really easy way to remember this list. It's a little dark, but it works. Just remember the phrase, "The appeal died COP." Each one of those letters stands for a specific type of order that you just can't appeal. And here's the whole list. You've got orders denying relief, interlocutory orders, we just talked about those, orders to execute the judgment, and even dismissals without prejudice, which basically means you can just file the case all over again. If you get an order that fits any of these DIDECOP categories, a regular appeal is the wrong move, full stop. But wait. Just because you can't file a regular appeal doesn't mean you're totally stuck. For these specific no-go orders, there's another door you can try to open. It's called a special civil action. This isn't about re-arguing the case. It's a totally separate action where you're arguing that the judge went way off the rails and committed what's called a grave abuse of discretion. It's a different game with different rules. All right, let's say you're in the clear. You have a final judgment and it's not on the DIDECOP list. Great. Now you have to make a choice, because there are actually 3 different ways to appeal a case from the regional trial court. And this table right here, this is your roadmap. It all depends on your situation. Did your case start in the RTC? Then you're taking the most common route, an ordinary appeal to the Court of Appeals. Was the RTC already acting as an appellate court, reviewing a decision from a lower court? Then you're filing a petition for review. But what if your whole argument is about a pure question of law, no facts involved? Then you can try to take a direct shot at the Supreme Court. Now, this is where we get serious. You've picked your path, you know where you're going, but none of that matters if you ignore the 2 non-negotiables, the clock and the cost. I'm telling you, messing up either of these is a guaranteed way to lose your appeal before it even starts. Okay, you need to tattoo these numbers on your brain. The first and most common one is 15. You have 15 days from the moment you receive that judgment to file your appeal, not a day more. Now, in some really specific and more complex cases, like special proceedings where a whole record on appeal is needed, the rules cut you some slack. You get 30 days. But then you have the other extreme. In cases involving habeas corpus, where someone's actual freedom is on the line, the urgency is off the charts. You get a mere 48 hours. The clock is ticking, and it is absolutely relentless. Now for the second non-negotiable, the money. And there's a very simple, very direct way to remember this rule. No pay, no play. It's as simple as that. And here's why that little phrase is so important. Paying those docket fees isn't just some administrative task. The law says it's jurisdictional. What does that mean? It means if you don't pay the full amount on time, the higher court literally has no legal power to even look at your case. It's an automatic dismissal. You can't be late, not even by a day. Okay, you're watching the clock, you've got the fees ready. Now for the actual paperwork. For a standard, ordinary appeal, your main document is the Notice of Appeal. And while it's a pretty simple document, you have to get every single part of it right.
Think of it as a 4-point checklist. You need to name the parties. You need to specify the exact judgment you're appealing. You need to state the court you're appealing to. And maybe most importantly, you need to include the crucial dates that prove you filed within the deadline. Miss one of these, and your notice could be fatally defective.
And just a quick side note on that record on appeal we mentioned, this is a different beast entirely. It's not a simple one-page notice. It's a whole binder, a chronological compilation of all the important documents in the case. You only need this for certain types of cases, usually when parts of the case might need to continue in the trial court, even while the appeal is happening.
So, you did it. You filed the notice, you paid the fees, everything is on time. So, what happens now? Let's get into the final phase, how the case actually gets handed over from the trial court to the appellate court. It's like passing a baton in a relay race.
This timeline shows exactly how that handoff works. When you file your notice, the appeal is considered perfected for you. It's locked in. But here's the interesting part. The trial court doesn't immediately lose power. It holds on to the case until the time for everyone else to appeal has expired. Once that window closes, boom, the trial court loses jurisdiction and the clerk can finally send the whole case file upstairs. The baton has been passed. But check this out. There's this weird little in-between period. After your appeal is perfected, but before the physical records are actually sent up, the trial court still has some leftover powers. They're called residual powers. It can still do things like approve a last-minute settlement, issue protective orders, or even, in some cases, order the judgment to be carried out early. It's a fascinating little quirk in the process.
So there you have it, the playbook. We've gone from can I even appeal all the way to how the case physically moves to a higher court. This isn't just a boring list of procedures. It's a strategic map. And knowing this map, knowing the no-go zones, your deadlines, your options, is what separates a failed attempt from a real chance at a second look. So now that you know the rules of the game, how are you going to craft your winning strategy?